Hello, everyone. Welcome back to the Water Online Show. We are in the flow. I am here with my illustrious colleague. He needs no introduction, but I'm going to give him one anyway. He is well known throughout the industry, Mr. Kevin Westerling. Kevin, we got another home run. We have another home run show here today.
Yes, we do. Looking forward to it.
We have a very special guest. His name is Ken Sansone, and he is a partner with SL Environmental Law Group. I'm going to go ahead and welcome him into our little ecosystem here so he can introduce himself and let our listeners and users know who he is and what his environmental firm does. Environmental Law Group does. So I want to make sure that I enunciate that correctly. But Ken, why don't you go ahead and let the users and listeners and viewers out there know who you are and what it is you do and how you serve the market.
Well, thanks very much, Travis. I'm very happy to be here with you and Kevin today. So yes, I'm Ken Sansone. I am a partner with SL Environmental Law Group, and we are a law firm where all we do is represent communities in cases over environmental contamination, typically, but not always, contamination of drinking water supplies. And what we do for our clients in these cases who are typically facing millions of dollars or more in environmental cleanup costs is that we identify the parties who are responsible for causing the contamination. Typically, these are the manufacturers of products that were made someplace far away from our clients' water supplies or our clients' other resources. But when used or disposed of in the ordinary course in those communities, ended up causing significant environmental contamination with chemicals that are effectively banned from drinking water as a result of regulations. And what we do through these lawsuits is help our clients shift the costs of complying with those regulatory mandates away from their ratepayers and onto the manufacturers where they belong. And I joined the firm a little bit over 6 years ago now. And before that, my whole legal practice had been in the public sector. I had been an assistant attorney general in the state of New Hampshire for several years. And now almost all of my clients are public agencies of one kind or another. So I really appreciate the opportunity to help these taxpayer-funded organizations make sure that they are putting the fiscal costs of environmental contamination back on these polluters.
It is a big issue. I mean, we are keeping the PFAS theme going here on the Water Online Show. We've covered it a couple of times from a few different angles. This is certainly one of the most intriguing and probably one of the most impactful here that we're going to dive into as to how this entire issue touches so many different parts of the community, the business world, the government-funded municipal world, all of those types of things. It certainly is widespread, isn't it? I mean, I'm surprised every day by other parts of the communities that are touched by it.
Yeah. So our conversation today is different than our previous PFAS conversations. Hence the lawyer. We don't usually have a lawyer on our program, but
not often.
Yeah, we have him here today. But that's how PFAS has really changed the landscape, and so. There are things utilities can do to kind of help them out as they try to, comply with these new regulations. Ken, thanks again for joining us. Could you give us a little background on how you first became involved in the whole PFAS storyline and the contamination crisis?
Sure. Thank you. So my firm was really founded, like I said, to help utilities who are in these situations where they're dealing with man-made contaminants that they have to clean up, and they know it's going to be expensive, and they don't have any choice because they have regulatory standards that they have to meet. And really, rather than suing local businesses or other agencies that may have used or released these chemicals as part of their operations, typically not having any idea of the potential environmental risks, looking at the remote manufacturers of these products who did know the risks and in most cases were the ones who profited the most handsomely from that. And so my firm had done a series of cases over gasoline additives like MTBE and chemicals resulting from fertilizer or pesticide applications. And then, of course, regulatory attention started turning to the problem of PFAS. And PFAS has a lot in common with some of these other chemicals that we had helped our clients with over the years. It typically gets into local water supplies because it has been in some product that was used or disposed of in the area, typically by other businesses or public agencies who were unaware of the risks. And in the case of PFAS, these are entirely man-made chemicals that were invented more or less by one manufacturer, and that's the 3M company, and were made more or less exclusively by 3M for a period of decades until 20 or 25 years ago when we saw some other manufacturers starting to get involved. So it wasn't really a big mystery as to who was responsible for the presence of PFAS in groundwater supplies in most places in the country. And as we saw testing increase, as we saw regulatory efforts intensify, we started filing lawsuits against 3M and some of these other manufacturers who were responsible. And ultimately, the number of those cases grew into the hundreds, and they were all consolidated into this centralized litigation known as a multi-district litigation. And that really provided us with an opportunity to move these cases forward in a very efficient way. And that's ultimately what happened.
I mean, in situations that involve legality, one of the most important things, as you know, as an attorney, I'm not educating you on something that you don't already know, but a lot of it depends a lot on precedent and legal precedent. So I'm curious, what has been a legal precedent that we can point to that sort of led us to where we are now?
So this really all goes back to the very simple principle that under the law in every state in the country, it's the manufacturer of a product who's responsible for the harm that the product causes if the product is defectively designed, or if the manufacturer fails to warn the consumers and other people using the product about the dangers of doing so. And this was a legal principle that was really invented by American courts back around the turn of the century, still in the throes of the Industrial Revolution. And it applies to the manufacturer of any product. So, we typically think of something like an automobile or a medical device that might injure somebody, but it also is true of chemicals, pesticides, fertilizers that can cause injury, not necessarily directly in the form of physical injury, but in the form of property damage, where you have water supplies that really belong to a community in one way or another being contaminated from the use of that product. And that was the precedent that my firm was relying on, as I said, when we started bringing these cases first over gasoline additives about 20 years ago or so. And that's the same principle, really, that we're relying on in bringing these cases against PFAS manufacturers. And it's proven successful.
That makes sense. That makes a lot of sense to me.
Yeah. And for our audience, a lot of them, water utilities, water suppliers, really comes to a head because they have to put treatment systems in place, obviously, for these upcoming PFAS regulations. So there's different levels of contamination all over the country. Is there any criteria that has to be met before they can apply or, qualify for this litigation and to maybe get restitution?
No, is the simple answer to that. So, PFAS in drinking water has really been recognized to be dangerous at virtually any level. And I think, we've seen confirmation of that very recently when US EPA finalized these draft MCLs for various forms of PFAS, most significantly PFOA and PFOS in drinking water, and set those MCLs at 4 parts per trillion, which obviously is a very, very minute concentration. But what ultimately has happened is, in recognition of the dangers that these chemicals pose at low concentrations, both 3M and another very significant manufacturer of PFAS and PFAS containing products, DuPont, have entered into class action settlements of claims against them by public water systems for contaminated drinking water. And under those settlements, a water system is eligible to receive payment even if its concentrations of PFOA or PFOS are below 4 parts per trillion. The level of concentration affects the amount of money that the water system will receive in the settlement, but any level of PFOA, PFOS, or any other PFAS compound, even those that are not yet the subject of regulation, is enough to make that water system eligible to participate in these settlements.
That really widens the playing field, doesn't it, Kev? I mean, it seems like there's just
everybody.
That's everybody, right? So we talk about being unlimited. I mean, when it's everybody, there's basically no limit. So I think I know the answer to this question, but just to validate and verify, is there a limit to the number of plaintiffs?
Well, it's a little bit complicated because these settlements were both very carefully constructed, and they were done so in recognition of the fact that there are so many different kinds of water systems across the country: groundwater, surface water, really huge municipal systems, tiny mutual water companies, everything in between. And of course, every public water system in the country is going to be subject to these EPA MCLs. And in order to try to sort all of that out, a structure was created where the settlement funds are separated into phases. And so in order to be eligible for what's called phase 1 under these settlements, a water system needed to have detected PFAS somewhere in its supplies, really by the time the settlements were announced. And that was in June of 2023. And so although the exact number isn't yet known, our best estimate was that there were about 6,000 or so public water systems that would have been eligible for phase 1. Phase 2 is everybody else. So that's more open-ended. As you're probably aware, there are still many, many water systems across the country who have not really tested for PFAS or have not done so in any systemic or meaningful way. Now, once compliance with UCMR 5 is completed, just about every water system, except for the very tiny ones, will have done at least some PFAS testing. And phase 2 was really created in recognition of that and also the coming MCLs. So I think this was structured in a thoughtful way to try to separate the water systems that have been dealing with problems of PFAS for years now from those that don't even really know whether they have a problem yet.
I'm glad that explains, already answers the other question I was going to ask, which is there a deadline? It doesn't seem like there really is one, except do it soon, right? There's no mandated deadline. Am I correct in that? But just get on it.
Yeah, so that's a really important question. So there is a deadline under each of these settlements for making claims.
Got it.
And if you are one of those 6,000 or so water systems that's in phase 1, if you detected PFAS at any level, any PFAS compound, anywhere in your system at some time before June 2023, you'll have been notified by an administrator who was appointed by the court for this purpose, and you are going to need to get a claim on file basically by the end of the summer. There were different deadlines under both settlements, but there's a late June deadline for the DuPont settlement and an early July deadline for the 3M settlement. So if you're in phase 1, you do need to act very promptly, and the claims process, as you might imagine, for something as complicated as this is a little bit demanding. You have to have documentation of your concentrations, the size of your sources, their production capacity, other information about your system. So my firm is working with about 250 different water systems across the country right now who are going through this process. And it's complicated. So certainly anybody who got that notice and had a PFAS detection before the end of June of next year, really should be working with a lawyer to try to make sure that they do all of this properly and get what they're entitled to under these settlements.
I know a good lawyer that can help. I do. Yeah. Yeah. His name is Ken.
Yeah.
You're all meeting him right now.
I appreciate that. Yeah, we are doing a lot of that right now, and it's really been an eye-opening project that, and this is coming from somebody. All I do is represent water systems. I mean, all of the different nuances that have come up in our work for all of these different clients on this has really been fascinating, and I hope, I like to think it's been a great help to our clients, because much of this is not self-evident.
Right. And my whole vision of it was like you in a courtroom battling it out against these chemical companies or something like that. But you mentioned these settlements. I was going to ask you about wins as far as that goes. But it sounds like, are the settlements already made, and you're just helping the utilities get the money that's, owed to them, or that kind of case? Or is there some kind of legal battle that's yet to ensue?
Yeah, so I guess all of that is true. So first of all, these settlements with 3M and DuPont came about as the result of years of legal battles that took place between my firms were handling these cases with, other law firms who were representing water systems as part of this process, and these manufacturers. And ultimately, just like we always hear the expression, this settled on the courthouse steps, that's what happened. We had a case ready to go to trial last summer, and literally it was the day before jury selection was slated to commence that these settlements with 3M and DuPont were finalized. So it was really the legal fight that produced these victories, and victories or wins is what they are. The 3M settlement is as much as $12.5 billion for water systems. The DuPont settlement, reflecting DuPont's smaller role in PFAS manufacturing, as I mentioned at the outset, is $1.185 billion, but that's still billion with a B. But the fight's not over, because there are a number of other manufacturers, particularly manufacturers of firefighting foam, who have been sued in these cases. There was recently a settlement announced. It's not yet approved by the court, with one of those manufacturers, Tyco, which is a very large chemical manufacturer that made a good volume of firefighting foam. But there are many other manufacturers who have been sued in these cases. The battle continues against them. So in addition to making sure that you get your claims filed under these settlements, another piece of advice that I've been giving water systems I talk to who are dealing with PFAS is, you do want to make sure that you are suing these other manufacturers to make sure you preserve your rights against them too. And of course, this is just on the drinking water side, which is what you guys are focused on. There are all kinds of other impacts that PFAS has on municipal operations, solid waste, wastewater, airports, firefighting facilities, and none of that has been resolved yet either. So the legal battles continue on those fronts too.
Even on the turf of the old vet here in Philadelphia, we did a show that focused on that, how so many former Philadelphia Phillies have gotten and we've lost to cancer, and many people blame it on the PFAS material that was in the turf. So you're right, it touches everything. But
yes,
if I get serious about money for a minute, just between you and me, how much are we talking about here? Would it be based on the size of the municipality? Would it be based on how much contamination? I mean, what are we talking about?
It is. So these settlements were set up, like I said, in a very thoughtful way, and in recognition of a pretty simple and universally accepted idea that, the worse your water is contaminated and the more water you have to treat, the more expensive it's going to be to do it. And as I'm sure many of your listeners know, that the typical treatment scenario for PFAS is usually granular activated carbon, GAC, just a big filtration system. You can also use anion exchange. In either case, it's steel tanks that are filled with some sort of treatment media that's going to need to be changed out over time. And so you have the initial expense of building a system, and then you have the ongoing expense of maintaining and operating it, including the change outs of the media. And the more water you're treating, the more often you're going to need to change out, the greater the volume of water you're putting through, the more tanks you're going to need. It's really pretty simple. And so the settlement really analyzes each contaminated source, whether it's a groundwater supply well or a surface water intake separately, assigns it a score based on these factors that I'm talking about. And then that score is going to be used as a basis for a prorated distribution. So you can't know exactly how much money you'll be getting, because how much you'll get depends on what everybody else gets. It's a pie that's being cut up into different size slices, but the slices of the pie depend on the severity of your impacts. And, we've been able to do some estimating, and, we have clients who we anticipate are going to get over $100 million from the settlement. We have clients who are going to get more modest payouts, maybe in the six figures. And it all makes sense because the ones that are getting 100+ million are very severely impacted. I have one client who has 100 contaminated groundwater supply wells.
Wow.
That's a very widespread PFAS problem.
Wells.
Expensive to clean up. Yes, of course. So the payouts are substantial. I will say, in the instance of transparency, that they are not going to be 100% of what, most, if any, of these agencies are going to end up spending to deal with this, particularly when you're talking about decades potentially of O&M expenses.
Mm-hmm.
But as is so often the case, there's only so much money to go around. You mentioned Phillies players who believe they've gotten sick from exposure to PFAS. There are thousands and thousands and thousands of people who have brought personal injury cases against these manufacturers saying they got sick from PFAS, including many firefighters who believe they got sick from their exposure to the PFAS and the firefighting foam. Those people need recovery and recourse at some point. Private well owners, I mentioned, other kinds of operations like wastewater, 3M, although a huge company, only has so much money at the end of the day to pay these claims. And, I think everybody recognizes that it's in our best interest, representing these claimants, that 3M remain a going concern and not end up in a bankruptcy process, which typically produces worse outcomes for everyone. So I think that, most of my clients, virtually all of my clients, have been satisfied with what they're getting. But I do want to recognize, as somebody who, tries to help shift these costs away from the taxpayers, that ultimately I do think taxpayers and ratepayers are going to get stuck with some of them just because of the scope of the problem. It's enormous.
Yeah. And unfortunately, there's been a recent development that may even increase costs for municipalities. But maybe not, because that judgment that came down was labeling PFAS, or certain ones, hazardous material, hazardous waste under CERCLA, for the Superfund program. And so now disposal of that is an extra expense. Now, under that program, polluters should pay. I don't know if that factors into your lawsuits, but certainly it could get more expensive for the disposal of PFAS. Is there anything since that decision that has changed for your law firm and your clients?
Yeah, I think there have been a couple of developments as a result of that. And, that's something that I think we all knew was coming. EPA had indicated its intention to list PFOA and PFOS as hazardous materials. And like you say, the listing of a substance as a hazardous material creates really lifetime liability for anybody who generates it, transports it, disposes of it, and the like, under the CERCLA statute. And so what we've seen, as a result of this, is increasing concern among wastewater treatment operators, because what they're doing is treating wastewater that, through no fault of their own, contains PFAS, and it tends to concentrate in their systems, particularly in the sludge or biosolids that they produce as a result of that process. And those biosolids are now going to be hazardous waste under CERCLA. And even before CERCLA, we saw a few states, including Maine, I think most notably, ban the use of biosolids for land application. Of course, these have been widely used as fertilizer because of concerns over PFAS contamination. So certainly, I think operational costs for things like wastewater treatment plants are going to be driven up as a result of that. But the good news, I think, is that a lot of PFAS contamination, certainly in groundwater, comes near military bases where firefighting foam was used by the Department of Defense and various branches of the military. The CERCLA designation, I think, is going to result in the United States government taking responsibility for cleaning up some of those sites. And that should help bring, I think, a little bit more money into these military communities to help clean up, and some of whom are dealing with PFAS at just shockingly high levels in their water. So
like us.
when
I've heard of that. I've heard of that somewhere. Yeah, I've heard.
Yeah. You might have seen some commercials about late night.
Look up the Horsham Way on Water Online, and you'll.
Oh yeah.
The article about what we covered here. Yeah. So, this may seem like an obvious question, but I'm going to ask you to throw out some free legal advice here. Water systems, as they exist now, if they're having issues with PFAS, should they still pursue traditional financing and to install the treatment systems for it, since they've already tested for it? Just to make sure that they stay on course in the compliance schedule. Should they continue to do that? I imagine you would probably say yes, they should, but I just wanted to make sure.
Yeah, so I always tell my clients to look at the lawsuit and the potential for recovery against these manufacturers, almost like another form of financing. And it's not to be pursued exclusively when you have grant or loan forgiveness programs that are available to you to help you pay for some of these treatment projects. And under the law, generally, getting benefits from some third party to help with an injury that somebody has wrongfully caused you does not prejudice your claim against that somebody who wrongfully injured you. That's another old legal doctrine known as the collateral source rule. So there's no harm to pursuing alternate sources of financing, and the settlements with 3M and DuPont recognize this. They do not penalize or offset recoveries in any way for water systems that have gotten grants, loans, and the like to help them with their PFAS remediation projects.
Good to know. So treat it like, okay, yeah, let's continue.
It's gravy.
Let's fix the problem. Let's fix the problem first.
Right.
And we'll let Ken do his thing and make us whole.
And it'll be an ongoing expense for as long as you're operational, probably. So the money will come to good use at some point. But for anybody who wants to get involved and is wondering, what is like the timeline for them actually seeing some funds out of this and for it to, get resolved, sort of?
So, I mentioned the deadlines for filing claims under phase 1 of these settlements. And, the sort of urgent news is that you need to act soon if you haven't started that process yet. But then, the good news is that the reason there are these deadlines is that the claims administrator needs all of this information so he can analyze all the claims and then start paying the claims. And there's no deadline that's been imposed on him for doing that. But, he obviously wants to act as quickly as he can. And when I say he, technically, the court appoints a single person, but he has a whole team of people helping him, and he is very experienced in dealing with these kinds of huge settlement claims processes. So we're hoping the DuPont settlement, it already has been fully funded by DuPont. All the money has been put into an escrow account. We're hoping that claims are getting paid by the end of this year. And then we'll move on to 3M, and we're hoping by, early or middle of next year that the 3M payments start to come out. 3M is actually on a payment schedule, so you won't get all of your 3M money at once, but you'll get about 70+% of it in the first couple of years. So over the next few years, if you're participating in these settlements, you're going to be seeing some real funds that can help you get started with some of these projects, which not coincidentally is going to be sort of the compliance period for these new EPA MCLs for PFAS.
I mean, that timing is a lot faster than I thought.
Yeah.
I mean, that's definitely encouraging. So, Ken, for all of our listeners out there and our viewers and the members of Water Online, I just wanted to ask so they know, how can they get involved with SL Environmental Law Group? What are the first steps?
So we do free consultations. You mentioned free legal advice. And I would invite anybody who is concerned about PFAS impacts of any kind, whether it's your drinking water or other municipal operations, to contact my firm. We have a website that has a wealth of information on it, and it has a function that allows anybody to set up a Zoom call with me or one of my colleagues here. And, we have to start by talking through the scope of your problem. But, one of the good things about PFAS is that it's pretty easy to figure out where it came from, or at least most of it. There were a small group of manufacturers, so it's easy to get the legal process started. There's not this lengthy environmental investigation that's required. Certainly, my firm has done that. In many cases, we have a full-time environmental scientist here. We work with, some of the top hydrogeology and industrial engineering and water systems engineering firms in the country to help put our clients' cases together. But so far with PFAS, we haven't had to get to that point. There's been a lot of strength in numbers with all of these cases being filed. And when you file a case over PFAS and the MDL, you don't immediately get launched into this big process where you're worrying about losing staff time to get ready for depositions and the like. It's a much more streamlined process. So I certainly understand concerns about getting involved in litigation. Nobody really likes it, but here I think it's a really important step, and it really does not come with the same burdens that you might typically associate with being dragged into a lawsuit.
This seems almost like a no-brainer as much as there is. I mean, if you're dealing with this, right, Kev? I mean,
call Ken, get your piece of the pie.
Right. Exactly. So SL Environmental Law Group, you can reach out to them at any time. As Ken said, he'd be happy to hear from you. Either he or one of his colleagues would be happy to hear about your case and what you're struggling with there from this standpoint. So is there a website they should go to first, or how should they contact you, Ken?
That's probably the easiest way. And like I said, there's plenty of information there about who we are and what we do. www.slenvironment.com. We have a presence on various social media, including LinkedIn. We're easy to find. And I should mention, the other huge concern about being involved in lawsuits is that lawyers are so expensive. We handle these cases on a contingency fee basis. So we get paid an agreed upon percentage of the recovery. And if we're not able to recover anything for you, we don't get paid. And when we get into the phases of these cases, if we do, where we have to start hiring expert witnesses that charge by the hour, we pay those in the first instance. And we're reimbursed for those out of a recovery if there is one. So no downside financial risk, no legal bills coming in. And we do it this way because, as I said, almost all of our clients are public agencies that would have a difficult time funding lawsuits against these huge corporations on their own. We handle that part of it. We've been very successful. We've recovered over $1 billion for our clients. So we have the resources, we have the expertise to be able to take these cases as far as we need to take them. And we have been in courtroom against these manufacturers battling plenty of times before.
Well, thank you, because we advocate for public water systems and you're advocating for them. So we appreciate that.
Yeah. Ken Sansone, thank you so much for the knowledge that you have shared with our audience, with our users, our watchers, our viewers, our listeners, all of it, the Water Online community. You are the man to know when it comes to this type of thing. So SL Environmental Law Group, go find them, go call them, whatever you need to do to contact them. They are your contacts and the help that you need when it comes to this type of thing that most municipalities and utilities are going to be faced with. If they're not already aware, they're going to be aware. So Ken, thank you very much for joining us. It was an absolute pleasure having you on the show. Much appreciated.
The pleasure was all mine. I can assure you, Travis. Thank you so much for having me.
Appreciate you, Ken.
And to all of you out there, all of our users, all of our listeners, all of our viewers, thank you for joining us once again here on the Water Online Show. We will see you next time.